Hi everyone. Today I'll be dealing with the case of Vivendi versus Argentina that was decided by ICSID, that is International Center for Settlement of Investment Dispute. Now this case is of very significant nature in international law, especially when it's come to international investment. This case arises out of the troubled relationship which developed between the parties to a 1995 concession agreement. So now what is concession agreement? Concession agreement is an agreement which gives right to a company to operate in government's jurisdiction or territory. Now this concession agreement which privatized the water and sewage services of the province of Tucumán, that is in Argentina. The original signatories to this concession agreement were a French company, that is Vivendi itself, and the province of Tucumán. The Argentina Republic was not a party to the concession agreement, but it is a party to bilateral investment treaty signed on 3rd July 1991 with the French Republic agreement between the Argentina Republic and the French Republic for the promotion and reciprocal protection of investments. Both Argentina and France are also parties to the Convention on the Settlement of Investment Dispute between the states and other nationals of other states, which entered into force for both states prior to signature of the concession agreement. The treaty had a provision guaranteeing investors a fair and equitable treatment according to the principles of international law in such a way that the exercise of the right is not obstructed. Now, what was the dispute? When Vivendi Corporation arrived there in Tucumán, they found neglected trailing system presided over by the corrupt provincial government, and not to mention that the corruption was endemic in Argentina political system. And to make the matter worse, the provincial government had objected to the national government's policy of privatization. The amount which was spent to repair the atrocious system and previous revenues were always insufficient. The first bill which was sent out was the larger than they had been used to. The provincial government of Tucumán fanned those flames and indeed quite corruptly did everything it could to prevent the investors unsuccessfully. For example, provincial regulators started filing vague and spurious cases to put pressure on the company so that the company would go away and then they could take over the restored system. All of these treatment was in violation of agreement which guaranteed a fair and equitable treatment. So now in 1996, company sued in arbitration. The case has a protracted history, the current dispute having been the subject of prior ICSID proceedings before the center. In those proceedings, pursuant to a request for arbitration filed on 26 December 1996, a duly appointed tribunal comprised of Judge Francisco, who was the president, and then Judge Thomas and Mr. Peter, rendered an award on 21st November 2000. It was the first award. On March 20 to 2001, a request for partial annulment was filed by CEA and CGE's successor, that is Vivendi, and on 3rd July 2002, a duly constituted ad hoc committee comprised of Mr. Y. Fortier, who was the president professor, and the ad hoc committee decided inter alia that the first tribunal rightly held that it had jurisdiction over the claims before it, but that it had exceeded its power by not examining the merits of the claims based on the actions of Tucumán authorities. Accordingly, the committee annulled the first tribunal's decision with regard to those claims. The ad hoc committee did not annul the first tribunal's finding with respect to the claims based directly on the allegations, actions of failures to act of Argentina Republic. On 26 August 2002, respondents submitted to the Secretary General of ICSID a request for supplementation and ratification of some aspects of the ad hoc committee's decision. By decision dated 26 May 2003, the ad hoc committee denied respondents' request for a supplementary decision, and with one minor exception, that is of typographical error. By a request for arbitration dated 29 August 2003, Vivendi and CAA resubmitted the dispute to ICSID. Claimants sought adjudication by a new tribunal of the issues as to which the first award had been annulled, namely the merits of their claim and arising out of the alleged acts and omissions of the Tucumán authorities. As to the merits, the claimants asserted that the Tucumán authorities denied claimants fair and equitable treatment in connection with the concession agreement and expropriated their investment without compensation. Clement said that the Argentine Republic is internationally responsible for the impunged acts and omission to the Tucumán authorities, and that the respondent has therefore violated Clement's rights under Article 3 and 5 of the BIT, that is Bilateral Investment Treaty. Clement seek to recover damages in sum of 310 million US dollar plus interest compounded at 9.70%. Tribunal said As will be evident from this award and our previous decision on jurisdiction, the tribunal has been greatly assisted by the submissions of the counsel, who in turn were helped by many others whose names do not appear in the transcription of the hearings. Now, what was the decision? In August 2007, the arbitral tribunal awarded the company the $105 million plus the interest, although it was still very much less than what it was asked. And later, the Vivendi awarded damages of 105 million plus 6% compounded interest. The tribunal said, on the facts before us, it is only possible to conclude that the provincial government improperly and without justification mounted an illegitimate campaign against the private investment from the moment it took office and aimed either at reversing the privatization or forcing it out. In particular, the tribunal held that the actions of Argentina's provinces were attributable to Argentina as a central government. On the merits of the case, the ICSID held that the respondent state violated the fair and equitable treatment standard within the meaning of Article 3 of the Argentina-France BIT. So now this is how the case went for more than 10 years, and finally Vivendi Corporation got the reimbursement and damages by the tribunal. Thank you.